And then I think before we went to a break, Tim mentioned something very, very important about the registration, how registration is so important, how the industry has to be regulated. Tim, if one may ask, is a consumer out there. Now, if I told you about how we operate, we have our own stock firm, we borrow money from our stock firm, and then we have our own family gathering, an arrangement, and then we borrow money there. Or people in the township, there's an old man, and then giving people, or in the village, is giving money. Now, can anyone go out and open up a criminal case because all these people are not registered?
Not directly, sorry. If you are providing services or loaning money or giving a lead counselling service or PDA service without being registered, there are various consequences that would flow from that. Firstly, the conduct must be reported to the National Credit Regulator, to the Complaints Department.
Which is you guys.
Which is our guys. We have various divisions within the Credit Regulator. One of them is complaints, that deals with consumer complaints. One is investigation and enforcement. So when the complaint is investigated, that someone is loaning out money to somebody that is not registered as a credit provider, the Complaints Department will investigate it. It will then be referred to investigations. They will do a formal investigation. They will work closely with the Hawks. They work closely with a whole bunch of government organisations. They would then go out and they would then refer matters to the Consumer Tribunal, which is specifically set up for these type of things. And there would be severe consequences. I mean, one of them is that the loaning of money would be unlawful completely, and the unregistered credit provider would be unable to recover any of the monies from the consumers to which they lend the money. So, there's a very, very large consequence. There's fines that can be given by the Consumer Tribunal. In some cases, I would think that that criminal charges would also be applicable. Especially when they hold the SASSA cards, which has become a trend, and which the NCR has focused very specifically on in current times. There was a raid recently in the Eastern Cape where there were recovery of the SASSA cards, many of them, where the credit providers then, as the SASSA payments come in, draw the money. There's also case law, recent case law that says that the SASSA payments cannot be used for the repayment of debt, or cannot be seen as income for affordability assessments by credit providers to provide credit to these people. So, very important that consumers check the registration. There's various ways to do that. You can go on our website, and there is a very specific section that deals with credit provider registration, PDA registration, ADR, the Alternative Dispute Resolution guys, credit providers, debt counsellors, and credit bureaus. So go on our website. Also, you can also go and check at the offices itself for the decal and for the certificates. And if you don't see that, ask the questions and see, make absolutely sure that these people are registered with us before you do dealings with them.
Now, am I going to be correct if I say, by merely reporting the matter with NCR, the chances are the consequence might be severe? Because sometimes people will think that I report and then it ends up there. Then you guys are going to come in and investigate, and people can be somehow be charged criminally, because I can assume that there will be some money hanging there or sitting there which borders around the issue of money laundering. And then remember, they don't do KYC, know your client, as much as they know each other as friends or colleagues. in a stock fair, but KYC goes beyond that in terms of getting the ID, getting the proof of address, knowing the source of income and all those things. So that is not done, and that is why we're talking about affordability assessment. So in other words, people need to be aware that it may lead to a lot of penalties, because sometimes it can be a fine, and then sometimes a fine can be coupled with imprisonment. And I know when it comes to your FIC and other laws, you can be fined as much as 10 million if you didn't do your KYC, or 10 million vis-a-vis 10 years, or combination of that. So people need to be very careful, because they may think that, no, I'll do it, they'll investigate and NCR will hold me. I don't think it will end there. Am I right?
Yeah, I mean, look at like recent successes. December last year was a good year or good month for the NCR. One of the registrants got deregistered after a thorough investigation and a trial at the National Consumer Tribunal. And the registrant were given R1 million fine, and their registration was cancelled. There was various contraventions of the Act found within their practice after we did the monitoring, and after a thorough investigation and the trial, the NCT pulled their business license and fined them. Also, you'd recall the ShopRite reckless credit matter, where consumers were given credit without affordability assessments. ShopRite was forced to repay that. There was also a fine of R1 million that was given to ShopRite at the time. So, yeah, in recent times there's been great successes from the NCR side. There's a lot of them that are not advertised. They're not very high level. But we are weekly in the National Consumer Tribunal with matters protecting the consumers from some unscrupulous registrants, or some registrants that just didn't know which way to go. So that we're very active. All our departments are geared to protect the consumers against registered and unregistered registrants that is just not playing the game correctly.
Will I be right? Remember, I'm asking a lawyer, so you put me right if I'm wrong. Will I be right, let's say ShopRite has been found guilty, like you said. Will I be wrong that, let's say, one of the clients, a consumer, on his or individual capacity said, they've been found guilty. Now I've got a case, I want to sue ShopRite. Can that happen? Is that a possibility?
I know that the National Consumer Tribunal can give a certificate to a consumer to go and get civil damages. For me, from a counselling point of view, has never been involved in something like that. But I do know that it's a competent order for the Consumer Tribunal to give you. That you then, as a consumer, can then take that certificate and go and issue civil litigation against a registrant for damages. It's got to do with your conditions of registration. Did you contravene that? Did you do what is good practice? And there's a difference between closing a practice and the damages suffered because of it. Now remember, the damages, if any, that was suffered from it is not damages to the National Credit Regulator. It's damages to the consumer. So what the regulator would do is enforce what they can in terms of the Act, in terms of the conditions of registration, and closing that practice or getting it deregistered is something that the NCR can do from a statutory point of view. Damages that flows from that are for a specific person. That damages are not for the National Credit Regulator. And the regulator will have no locus standi to issue summons or civilly get that. That is the consumer. And the consumer is the one that would know what is the extent of that damages and can quantify and prove such damages much easier than the regulator would. So it is completely two parallel processes, and the one would run mostly without the other.
Okay. Now, Earlier on, I was talking of from an individual perspective. I'm sure you are aware now what is happening in the world is what we call class act, whereby people go as a group. Any chances of class act
Class acts.
for such damages? And then let's say one individual feel that I have been damaged, then put all the people together and say, let's go for class act for all of us.
It's not as simple as that.
Yeah.
Remember, class acts, you need to bring an application to authorize you to bring a class act. Yeah. And I'm not sure about the onus, but I'm sure you have to show that all these people have suffered damages because of the act of the same person or persons, and that it would be in the interest of justice that everybody be heard at the same time. And then you would obviously argue that there is a cost saving and a time saving for our courts if you hear it all together. So it's not something that you can just on a Saturday afternoon get everybody together and say, let's do a class. You have to have authority from a court to do that.
The big R is all about financial education. I just want to simplify this. Some people might say, oh, now team and so what are you talking about? What is a class act? Do you want to define class act for our consumers out there so that they understand what is a class act? I know earlier on you have just explained it, but I want you to elaborate so that our people can understand that there is still an opportunity of class act, individual act. Remember, the regulator has already done its job. So I wanted to find out whether there is still an opportunity of individual damages or class act. If you can explain the class act for the consumers out there to understand.
Yeah, I think the individual consumer have to have a right to damages. And various individuals from the same negligence or from the same act of somebody else then suffers damages which is more or less equal to each other. So instead of the one person going to court and say, I want to claim civilly, all the people that were affected by a specific registrant's or a specific person's act or omission
or incident
would then come together and say, okay, we are not only one applicant, we are 500 applicants. Can then come together and say to a judge, okay, we suffer damages because of more or less the same incident. All our evidence are going to be more or less the same. And because of that, we want it all heard at once by the same judge in the same court with the same lawyers. And that is the cheapest way because there's obviously then cost sharing between them. So instead of one person paying 6,000 Rand for an attorney for a day, as an example, 600 people will pay 6,000 Rand a day. So it significantly cut the legal costs of these people. And it significantly decreased the time that 600 matters, civil trials, would have been instead of one.
Yeah.
So, but like I said, it doesn't happen often. And you need prior authority for such a class action to be taken.
I'm asking this question because I know there was a case in point, Durban, whereby a dead counsellor was found guilty, although the matter is sub judice, because the dead counsellor has taken the matter for appeal, which is within her rights to do that. Maybe not diverging on the matter, on the basis that is sub judice. What can you give people out there? Because I'm sure there are some dead counsellors. Maybe they are not aware of this thing that has happened. And then just give them and understand what's happening in the industry.
Probably it's a very broad answer that you ask. If we look at the Consumer Tribunal's ruling, the Consumer Tribunal found contraventions of almost every section of the Act with regards to that registrant. And it mostly flowed from call centre operations, where the call would be made to the call centre. There are agents that are not debt counsellors that would take the call, that would collect the information of the consumer, and then do affordabilities and do income and expenditures and do proposals and all the rest, where they are not trained in terms of the National Credit Act to do that. Now, the National Credit Act is very clear that you have to be a debt counsellor, a registered debt counsellor, to perform certain acts. And those are, especially when it comes to declaring you're over-indebted. And that was a big part of the judgment, where these agents in the call centre were not registered. They didn't know what they were doing. They were declaring consumer over-indebted when they were in actual fact not. They were placing consumers on the credit bureaus where they have actually not applied, where they've only did an inquiry. So that's where it all started. And if I can deviate from your question at this stage, debt counselling is exactly that, counselling. And counselling is sitting around the table, looking at the situation that you're in, and be counselled by someone that is properly trained to give you that counselling. If you look at trauma counselling in the medical fraternity, you can't just go to anybody that doesn't know what they're doing for the trauma counselling. That's not going to help you. It's going to be even worse for you. And if you look at a lot of judgment in recent times by the courts, and the courts think that counselling needs to be put back in debt counselling. And I think when counselling are put back in debt counselling, it's going to become what it is supposed to be. It needs to counsel you. It needs to take that trauma of your debt stress out of you. And can that be done by a call centre agent that is not a debt counsellor that is registered? I don't think so. So what the Consumer Tribunal then said in that judgment is, get back to counselling. Both you as a debt counsellor and you as a consumer. Get counselling, give counselling. And that is the way for you to move forward. And that is the way for debt counselling itself to work for you as it is supposed to.
You know what? Now, talking from the position of a debt counsellor, we are in a world now where technology is very important. We are incorporating technology to all business that we are doing. And I can see now the courts are allowing that now you can serve via email. Unlike being rigid, registered mail and so on, can serve by fax. Now, a debt counsellor, here is a debt counsellor. He's doing a counselling, as you are saying, but over the phone. He's counselling somebody in Umtata, Eastern Cape. Will that be wrong?
No, there's no regulation against that. But I think the consumers need to start standing on their rights. Mm-hmm. A consumer is going to pay for a service. A consumer is going to be paid to be counselled. Mm-hmm. And the consumer needs to get the value for their money. Mm-hmm. I had a call yesterday morning by a consumer that only had a discussion with a debt counsellor and had certain questions. And the consumer phoned me at the office, and we spent about 28 minutes just discussing debt counselling. What does the proposal mean? How does it get out? What do we respond? And at the end of the discussion, I said to him, you know what? I actually wish that every consumer was like you, because consumers think that when a debt counsellor becomes involved, their personal finance is no longer their problem. That is not so.
I know what you're talking about.
Your personal finance is your personal responsibility. Yeah. And just because a debt counsellor is negotiating on your behalf does not mean it's not your problem. Mm. Your personal financial well-being is your personal responsibility. Mm. And I think if people start taking that seriously, as it should be, then counselling should follow, and counselling then becomes something that is important to you. And that is where we need to go back to. We need to go back to basics. We need the consumer involved at every single step of their own financial journey. It's not your financial journey as a head counsellor. And then when they demand a higher level of service from the head counsellors, that's when the industry will really be giving the benefits.
You know what, as you say that, it resonates with me. I had one client, I normally talk to various radio stations explaining that counseling and so this guy came to me, very old man, pension, but he was making money. He had business, and then the business was making money, was generating money. So once he went on a debt review with me, it was in December. And remember, when there's a counter, there's no way I can accept having not spoken to the client and say, look, there's a counter. Then when I phoned that client, I said, hey, Chola, did you see his when? It's December. It's my time with my family. I want to relax. Sort them out. It's your problem. It's not mine. So I know exactly what we're talking about.
Absolutely.
So it was saying that in passing. I heard you speaking about SASSA cards, ID. Then the follow-up question that I would like to ask. A pensioner, can a pensioner apply for that loan?
No, that's a good question. Firstly, the most important part of debt counselling is that you have an income that can pay your creditors. So straight away, someone that does not have an income, an unemployed person, with no recent prospects of finding employment, is not a candidate for debt counselling. Pensioners, it depends obviously on the income they have. If they're on an income grant, like I said, there are case law that says that grants are not income for the purposes of repaying debt. So it cannot be brought into consideration when, for a debt counsellor, for an example, is doing an affordability assessment for repayment. So, that would be on a case-to-case basis. You would look at the asset base. As a debt counsellor, you would know that any luxury goods needs to be disposed and to pay debt. But that would be something you look at a case-to-case basis.
Okay. While you're still there, there are a number of issues that I want us to do. I want us to look at advert for debt counsellors as they advertise. We'll go there. One of the questions that I want to know, what advice do you have for a consumer out there who's looking for a debt counsellor? What advice can you give as the national regulator?
As our discussions earlier, the consumer needs to look for someone that's going to counsel them. So trust right off the bat is very, very important. And there's certain ways of the consumer looking if they can trust this company. The first one is obviously to see that they are registered with the National Credit Regulator. And a very important part of that is the unique number that the regulator gives each registrar. So like with your DC number, your DC number, nobody else will have it. And it becomes important for you as a debt counsellor to display it. So when you see an advert of a debt counsellor and it doesn't have his debt counsellor number on it, doesn't have his address on it, doesn't have his phone number on it, do not trust it. You get a DC number for a very specific reason. And the debt counsellor should use that at all times to identify themselves. Second point on that as a consumer, be very careful of the debt counsellors that make debt counselling to be a savings plan, where they advertise that you can save 63% of your.
I've seen that most of the time. Or you pay 50% of what you used to pay.
And debt counselling is not a savings plan. Debt counselling is an arrangement between you and your credit providers to lower your interest rate, extend your term, to make sure that you pay your debt off as soon as you can. So this is not about having money in your pocket at the end of the month. This is about living decently, having a decent amount to buy food, pay school fees, to do transport and the rest, so you can live, and then take all the other available monies to pay your credit providers. So it's not a savings plan, and if anybody's telling you it's a savings plan, you cannot trust them. If any debt counsellor advertised get 50% of your debt written off, that is not what the Credit Act is all about. The Credit Act is about paying the money back that you've used, that you got the benefit from, and that you actually owe your credit provider. So it's not a savings plan, it's not a write-off program, it's nothing like that. So guys, be very wary when you see that. Also, where people are using the National Credit Regulator's logo, they're not allowed to do that. It's copyright protected. And when you see the logo...
Hold on. Just there. I've seen, especially in the advent of social media, I've seen a company having their logo, and then underneath there's NCR logo. Is that not allowed to show that I'm registered with NCR? Or should they ask permission to use NCR logo?
You see, it's much more complicated than that. You would not like that. If I take your big R, I put it on my company and I say, you know what, I'm associated with a big R. I mean, you got copyright.
Copyright, you said.
So does the National Credit Regulator have copyright on its logo. The NCR only give permission for logo usage where we have a joint training venture. So if we do workshops with somebody nationwide, then they're allowed to use our logo. Our logo is not to be used on headers, footers, emails, advertising, websites, anything. You are not allowed to use the NCR logo. And when you see that, as a consumer, be very, very wary of dealing with that debt counsellor.
In one of the discussions, there's a lot to talk with you. Hence, probably sometimes we make a follow-up via Zoom because you are busy, so that we give you space, You mentioned the Marikana, very nice topic. Because I think people have tend to forget that Marikana incident, when it all started because of money, mashonisa. Then it unfolded to another animal. So you said you guys went in there. What did you discover? What happened at Marikana? I know you mentioned a bit, but if you can give us flash, what did you really discover as NCR when you went in there?
Just to let you know that I am not in the investigations department. I'm in the debt counselling department.
Yeah.
So this is research that I've done afterwards. So I cannot tell you from our investigation and enforcement departments what they found. But what was reported in the media was where the SASSA cards were held, or their bank cards were held, and
IDs for
that matter. And then as money came into the account, they would the machinistas would draw them all out. So the consumers would sit with absolutely no money at the end of the month.